Let's look at the law of contract and also the essential ingredients of a valid contract. Because for a contract to be valid, there are some characteristics, there are some features that it should possess. So we are going to look at the ingredients. This video may be in series because when we're talking about contract, it is so important and it is detailed. So we'll look at what a contract is, the types of contracts, simple contracts and specialty contracts, their differences and similarity. We are going to look at ingredients like offer and acceptance. Consideration is important. Intent to create legal relationship is important ingredient in a contract. We are going to examine to the legal or legality, the legal capacity of individuals involved, and also the object of contracts must not be illegal. We are going to look at the object of the contract. So these are some of the vital essential ingredients that will make up a valid contract. We are going to dwell more on offer because everything that I just spelled out as ingredients, they are a bit elaborate. And you know, when we're talking about law, it comes with examples and precedents, which one or two examples will be given along the way. So we are going to talk about what an offer is, the definition of offer, types of offer, like the specific, the general offer. We are going to talk also about invitation to treat. Have you heard about invitation to treat before? So we are going to examine it in this particular video. We are going to know what a counter offer is. We are going to examine what a cross offer is too. We are going to also examine how to lawfully terminate a valid contract and a valid offer. These are some of the things that we are going to cover in this tutorial, and we are already going into our dashboard already. So if you are just joining us, my name is Gbenga Olatunji, and we are love that you subscribe to GJAMES Associate channel so that anytime we upload new video, you will be first to receive it. We are on Facebook, we are on Instagram. Please follow us, like us there too. Let's go straight into the business of the day. What is a contract? So we are going to be talking about a contract. So here in lay term, we can say a contract is an agreement, right? So a contract is an agreement between two or more persons with the intent of making it to be legally binding. Please don't forget, you know, when we're talking about legality, and as a law student, we should try as much as possible to marshal our point correctly. So a contract may be defined as an agreement between two or more persons which is intended to be legally binded, because in law intent is not enough. That's, oh, we had a discussion and we have an agreement to do certain things. That's intent. That intention must to have it legally binding on all of us that agreed together. Okay, so basically that is what a contract is. Now there are types of contracts. Types of contracts. Then we'll be talking about the simple contract. It could either be simple, just like life is simple, right? And if it's not simple, we have a specialty contract, special. We are special, specialty contract. Those are the two types of contracts we have. So when we are talking about a simple contract, always arises from agreement between parties, maybe starting from being verbatim, then it progresses and the like. But it just start like, okay, can we do this business together? Let's look at it. As simple as that, we are already going into a contract, and we can call it a simple contract. But it may, even that simple contract may go to become a bit of complex, because part of a simple contract, let's take for example contract of employment, is a bit simple, but we know that within the two parties, one has upper hand, which is the employer, especially in some economy where labor law is not that enforced, or the population is more than available, and rate of unemployment or underemployment is higher. So we are not we are not going there anyway. Let's continue. So where it's a simple contract may be complicated too, in which the two parties are not having equal right or equal capacity. So a simple contract always rises from an agreement between parties, although in reality one would, that is a party, would find out that one of the two parties have a bit of higher platform to operate from. But nevertheless, it's still a simple contract. So let's quickly talk about specialty contract or contract. Specialty contract. When we're talking about specialty contract, it's belong to a class of contracts made under seal, made under seal. And for us that are accountants, or accountants to be, or entrepreneur, but that understand doing the right thing, one thing is important in our invoicing, which many times we neglect. Now, don't forget we are talking about specialty contracts. Our invoicing to our clients when we want to make sales and the like, we fall under this category. Specialty contracts. What make a specialty contract is that seal, the deed that's on it, which sometimes we can call the stamp duty. So this type of contracts requires the observance of special formality for their creation. So for a deed, it, it must be signed, a specialty contract must be signed, sealed, and delivered. And example of it is our invoicing. It is under the law, before we can prove a sales or the like in the court of law. It's ordinarily those documents should carry duty, which we call stamp duty, should be under seal. That actually makes the legality. Don't forget, when I started, we talk or spoke about the intent, but intent is not good enough in law. We should try as much as possible to follow through everything the law prescribes to make a contract binding. And for specialty, not simple contract now, it should be signed, sealed, and delivered, because it's in that deed that the legality of the agreement actually lies. Having established what a contract really is, I hope we will not forget what a contract is. Towards the end, I'm going to recap it. So help me God. We've spoken about contracts, types of contracts. We've spoken about offer, types of offer. Let's go into distinction between an offer and invitation to treat. Don't mind me, lecturing is in the blood. We are yet to deal with the offer. Let's deal with what an offer is. What is an offer? Don't forget, offer is a critical ingredient of a valid contract. So an offer can be defined as expression of a person's willingness to enter into an agreement or into a contract. An offer is an expression of a person's willingness. So the person is not forced. That is what we are talking about. It's the expression of somebody's willingness to enter into a contract. So the parties must not be coerced for a contract to be valid. Don't forget, number one ingredient of an offer is that of a contract, binding contract for that matter, is that there must be an offer, and of course there must be an acceptance. But now we are dwelling on offer. So an offer is an expression of person's willingness to join force in the contract. So generally, there are two types of offer: the specific and the general offer. The specific offer and the general offer. Should I put something down there too? When we're talking about specific offer, a specific offer actually is made to a specific person or specific persons who alone can accept the offer. So it is a specific offer. So we go from the simple to the complex. So a specific offer is the one expression of a business dealing together or the like that is addressed to an individual. Specific is correct. So the let's say Mr. A makes an offer and Mr. B or Mrs. B accepts it. So that's a specific offer, an offer from Mr. A to Mr. B. That is a specific offer. So a general offer is an offer that is made to the world at large. So it's not addressed to a single personality or a single entity, but addressed to the general world. And I'm going to give us a classical case of decided case of Khalid versus Carbolic Smokeball Company. Basically, it was just like in the time of COVID now that just passed, the recent past. Then it was influenza that is ravaging the world. And Carbolic Smokeball Company was an organization actually there then, and they made an offer. The company claimed to cure influenza and promised to pay anyone who uses their smoke ball or their pill now in a prescribed manner for a prescribed or specified period of time. And if the person or persons still contract influenza and their influenza, which we call katana, if the kata did not go or refused to go, Carbolic Smokeball Company promised to refund £100. So the plaintiff, now that is the person that took them to court finally now, bought the smoke ball, the pill from the company, and they used it as prescribed for the prescribed duration of time, and the influencer or kata refused to go. So She actually sued Carbolic Smoke Ball Company, and you know what? It was they refunded our money. So that is a valid example of a decided case on a general offer, because Carbolic Smoke Ball Company wouldn't have known whose kata, whose influencer would not go. But at the point of sales, at the point of advertisement, I'd made that general offer, and Khalil went for it that our own influencer did not go, and the organization paid her back our money. So that is an example of what a general offer is made to the general public. Meanwhile, a specific offer is offered to an individual. Now, let's go for offer an invitation to treat. So talking about an invitation to treat, let me write it down. Invitation to treat versus offer. When we're talking about invitation to treat, we are talking about an offer made to the general public, just like the second type of offer, which is general. But here, it's not made to specific person, and until somebody actually offers. So the person that ordinarily should stand like the offerer, offerer, or offeree. Those are the two parties which I've not even spoken about. Let me quickly speak about that, then I move on to discuss the invitation to treat so that we can lay a solid foundation. In an offer, you know there will be two parties, and the two parties are called the offerer and the offeree. So the offerer is the person that offers maybe a service, that offers a sales, a promotion, and the like. The offeree is the person that bought into the offer, which we can call accepted it, which we can say has accepted the offer. So that is an offer, and it comprises of two parties, the offerer and the offeree. Now, invitation to treat. Invitation to treat is an offer that is not made to an individual. Let me give an example, because it's only by example that we can get the distinction between an invitation to treat and an offer. Let's say I'm selling meat pie and the like, and I displayed it in a show glass, maybe in the frontage and the like. Displaying my meat pie, my chicken pie in my show glass is to invite anybody that wants to buy. They could get there and I could tell them I'm not selling, sorry, and I could sell for them. So displaying goods is not the same as offering it out. It's only an invitation. So if somebody displays his goods or service and somebody patronizes, the person that is now patronizing is now the offerer. Please don't forget this example, because a question can arise, can come. I say, in this given scenario, who is an offeree, who is an offerer? Of course, it may not be more than 1 mark, half mark, but nevertheless, it's so cheap. The person that came into the store to buy now is the offeror. Then the person showcasing in the show class that invites could either agree to sell or not becomes the offeree. So please don't forget, it's invitation to treaty is like the opposite of offer, and the parties in invitation to offer is the reverse of the parties to an offer. Please don't forget. Please don't forget. Let us move on so that this will not be too long. We've spoken about distinction between invitation to treat and offer now, and types of offers, and also we've spoken about parties to an offer. Let's talk about counter offer. Counter offer. Let's talk about counter offer. Please and please, even though we have ingredients to a valid contract, but please, this video will just deal with everything about offer, and we continue from acceptance, consideration, intention to create legal relationship, legal capacity, and the object of the contract, which are valid ingredients of our contract, but so that it will not be long. Okay, so what is a counter offer? Now that we know what an offer is, what is a counter offer? When we are talking about counter offer, a counter offer definitely will take us to negotiation table. So when we are talking about a counter offer, we are talking about a situation in which an offer cancel out another. An offer will definitely cancel out the other one. Instead of the offeree to accept now, he or she made another offer. Example, let's say I want to sell my biro or a pen. I want to sell a pen for whatsoever price, and I've given my opinion out and the expression, the intent to sell for the purchase consideration for that amount. And somebody walks in, say, okay, the pen is very good, but I can only buy it for so and so amount. Well, that was why I said initially a counter offer will definitely takes us to a negotiation table before we can really understand it. You know that between the two parties, a negotiation has started. So if they did not decide on which price to go for at the end of the day, or which party, which side wins the negotiation, then the offer cannot stand. The offer cannot stand. Especially, let's say Mr. A or Mrs. A is the one that gives the first offer. Mrs. A wants to sell shoe or lace for XYZ price amount, and Mrs. B comes in and offers another price. Of course, most likely will be lower price. Mrs. B's price counters Mrs. A's original offer, and if they did not agree, Mrs. B's price cannot stand in the law court, and it could be counted as, unless Mrs. B accepts Mrs. A's offer to sell her lace or shoe at that particular price, then no contracts has taken place. No contract has taken place. That is a contract. Also, we could have a crossover, and don't forget, I'm just trying to make an understanding of a contract. Of course, I'm not a lawyer. I'm a chartered accountant. A crossover is or are two offers that are so identical in term. They are so identical in term, and they need to, just like counter offer, but unlike the counter offer now that A offers maybe a higher price and B offers a lower price, and there are negotiations going on. In a cross offer, there are similar offerings given out, and we just need to know what really do we want is being offered. So we need to understand first what is being offered in a cross offer. If not, offering has not even taken place. There's no contract to say it as it is. In a cross offer, unless there is an agreement to a specific offer among the identical offers, in a cross offer there will always be identical offers. Let me put it down. And there is no contract unless there is an agreement as to the understanding of what are we really offering. Just making a simple understanding, please. We move on to termination of offer. Termination of offer. When we continue, we'll discuss other vital ingredients of an or of a contract rather, but we are dealing with everything as much as possible about offer. So termination of an offer, we cannot just terminate an offer or a contract that were established. There are things, features to look out for a good closure of an offer. Primarily, an offer could come to an end by termination and by rejection. You just reject. So we can bring an offer to an end by rejection. So an offer can come to an end by rejection. I simply offer you something and you simply say no. It comes to an end. That offer comes to an end. We can re-offer another time, but that one comes to an end. Another way that we can bring an offer to an end is by counter offer. Counter offer. Don't forget, we just dealt with counter offer. Now, when we are talking about counter offer as medium of terminating an offer, it simply means if I propose a particular price and you say in negotiation, can I offer you this amount? Simply saying it, like I said before, unless we agree to that price, the first offer is countered and is terminated. So there is no offer, there is no contract that can take place. And that is why in negotiation, there must always be agreement. Okay, I'm not selling this, okay, pay this and the like, okay, it's okay. Then we agree, then we accept. So in a counter offer, that simply means that the first offeror may finally have to become the offeree. I hope we understand. I don't want this video to be too long. The final termination method we can use in termination of an offer is by revocation. See, is by revocation. And when we are talking about revocation, expression of revocation, let me write it, revocation. Expression of revocation must be brought to the other party. So the offeree must be aware that the offeror has revoked the initial offer. I want to believe we know who an offeree is now, who an offeror is now. A quick recap. My name is GJAMES. My name is Gbenga Olatunji. My name is GJAMES too. And you are on GJAMES Associate platform. For those that are meeting us for the first time, we love that you subscribe. Click it all as notification. Share, and follow us on other platforms. GJAMES Associate on Facebook, Gbenga Olatunji on Facebook, GJAMES Associate on Instagram, Gbenga Olatunji G at Instagram. Please follow us, like us also. We've spoken about contracts, and we said a contract is binding. Please don't forget, a contract, an expression that is binding. Binding who and who? Binding the parties to the contract. So for a contract to take place, there must be expression with the intent that the expression of that contract will be binding on us. And there are essential ingredients of a valid contract. And we spoke about offer, and actually we dwell on offer. Also, acceptance will be the next we will be looking at. Actually, we'll be looking at acceptance, which is another ingredient which we did not dwell on. Now, consideration is involved, intention to create legal relationship is involved, the legal capacity is involved, and the object of the contract are valid ingredients of a valid contract, which we will be looking at next. Then we've spoken about an offer. We said it's a definite expression of willingness to enter into a contract. And we've discussed about the types of offers we have, the specific and the general. We've elaborated it. The parties to an offer, the offeror, and who an offeree is has been discussed. Also, we've discussed the difference between offer and invitation to treat. Please, if you are hearing it for the first time and you are preparing for a law exam, please go back and examine it. We've spoken about counter offer, we've spoken about a cross offer, we've spoken about how to terminate an offer, and in terminating an offer, we said it could be rejected, an offer could be countered, in which is counter offer, and an offer could be revoked. All these three elements too, they have a way that we need to go about them for them to be valid and the offer becomes validly terminated. From GJAMES Associates, Gbenga Olatunji FCA, we are value to life, we are value to your businesses. Next time, let's meet to discuss acceptance, which is another vital ingredient of a valid contract. A contract must start with an offer, and it must be accepted. Let's come together and know how to accept and the ingredients of a future of a good acceptance.